go.
Well, good morning, everybody. This is exactly the way you wanted to start a Thursday morning, is geeking out with a couple of lawyers. Grab your coffee. If you're just watching this on replay, grab your teriyaki lunch. Sit on down. We're going to geek out for a little while. Look who I got here, everyone. I got Joe LoPorto, Director of Legal Operations with ANJRPC. Joe, why don't you tell everybody about yourself and all the cool things you guys are doing out there in New Jersey? And thank you very much for being here with us.
Yeah, sorry, quick correction there. Our organization is New Jersey Firearms Owners Syndicate.
That's right. I'm reading off the case. New Jersey Firearm Owners Syndicate. Yeah. You are the Director of Legal Operations there. Thank you for that.
Correct. And our direct nexus to these cases is our founder and president is a gentleman named Mark Cheeseman, who's the title plaintiff.
Named plaintiff.
The named plaintiff in Cheeseman v. Platkin. So that's sort of our broad nexus to these cases. But yeah, so our organization is we're a 501c4 Second Amendment advocacy organization. Our primary activities are I'm responsible for running our litigation portfolio, and we've got a number of cases that are currently active.
And you're getting more active out there. We were talking before we went live that the New Jersey is really kind of becoming the epicenter of a lot of major Second Amendment challenges now.
Yeah, it is the sort of perfect breeding ground for this. You know, we have the combination of now, and we'll get into this in some detail in a moment, but you know, we now have the combination of a fairly, I don't want to say conservative, but a sort of true originalist majority at the Third Circuit Court of Appeals in combination with a state with an awful lot of terrible gun control laws.
Yes.
So, you know, whereas let's say the Fifth Circuit has got some great judges, but there's just not a heck of a lot of gun control in Texas, whereas we've got lots and lots to work with here. So it's a target-rich environment here in the state of New Jersey.
Well, and I think that's what's probably brought about even more attention to the cases out in New Jersey. Now, they go by a couple different names. There is ANJRPC, which I believe is the Association of New Jersey Rifle and Pistol Clubs versus Attorney General of New Jersey. And then there's the case that you guys were directly involved in, which is Cheeseman v. Platkin. They all got consolidated for an en banc review before the Third Circuit yesterday. And we've done some videos on the channel. There has been a political shift in the Third Circuit. Do you agree with that?
It's monumental. If you look at the real composition of things, yeah, there's currently Michael Shigards is the chief judge. You know, he was a Bush appointee, and we have Judge Hardiman, who another Bush appointee, but we could really think of him as being sort of in the Trump camp, because for those who may recall, he was on the short list to fill a Supreme Court vacancy during the first Trump administration. So we could call him a Trump judge. And then now with the recent addition of Jennifer Mascott to the circuit, we now have an 8-6 majority.
Right, and then you had Emil Bove also get there. And I noticed at the beginning of oral arguments, the Chief Justice was kind enough to introduce the new justices to the Third Circuit. So
yeah, that was a real, you know, sort of surprise to us. You know, we were obviously watching it closely, but you know, for those, you know, a little bit of inside baseball here, you know, there's sort of 3 steps to the sort of nomination process when we're talking about, you know, appellate court judges. They have to be Senate confirmed, and then they have to receive their commission from the White House, and then they have to be sworn in. Typically, that initial swearing in is typically done in private, and then there's usually, after that judge is seated, there might be some, you know, more formal event to sort of make a public event out of that nomination. But the initial swearing in is typically done in private, and you just don't know. You know, like we knew she was confirmed, we knew she received the signature from Trump. We just weren't sure what was going to happen there. And then roughly a half an hour before before oral arguments started, we learned, because the staffers in the room were doing mic checks on all the different stations, and they did a mic check for quote unquote Judge Mascot. And as soon as we heard those magic words, Judge Mascot,
yeah, did the room light up?
Yeah, the mood changed dramatically. Both in the room and everywhere.
Well, that's why I wanted to bring you on. So yesterday, I listened to the oral arguments a couple times, and I was cutting up the audio clips and figuring out what video we were going to do about it on Washington gun law. And then I was like, man, I'm just listening to audio clips, right? And how much am I truly capturing of what's going on in the courtroom? I can understand the intricacies of the legal arguments, but there's more to it than that. There's an atmosphere, there's an environment, there's reading faces, there's looking at body language, there's the tone of questioning. There's you're a lawyer, you've been in the courtroom yourself. You know that there's a lot of things that goes into reading the tea leaves. So before we get into some of the specifics, I want to take you through on what happened yesterday. I want you to describe to the viewers what the general mood and atmosphere was like in that courtroom. And did any of that catch you by surprise, or was it what you expected you were going to see?
Yeah, so our president, Mark Cheeseman, was sitting front and center for the whole thing, as both a plaintiff in the case and as a sort of representative of our organization,
Right.
sort of show of force alongside with our friends and colleagues at ANJRPC, who's, by the way, our state NRA affiliate. So the main groups that are involved here are ANJRPC and the NRA and Firearms Policy Coalition. So we sort of had all of our supporters in the room, and you're right. There's a lot that was lost in translation there. I think if you just listen to the oral arguments on a live stream, I think it was pretty clear where a lot of these judges lie. I mean, there was
Yes.
a healthy degree of skepticism vis-a-vis the state's arguments throughout the entire proceeding. And similarly, I don't think we heard that level of skepticism when listening to our side of the argument as presented.
I agree. I felt as though both Miss Murphy and Mr. Patterson, I believe it was the two, because one argued on behalf of the ANJRPC plaintiffs, and then Mr. Patterson, I believe, was arguing on behalf of Mr. Cheeseman and all
Correct.
that. And by the way, I think Miss Murphy, who's now become a real veteran at doing these things, and I've listened to arguments, she's like fine wine. She just gets better and better each time. She really does. I thought she did a great job. I thought Mr. Patterson did a great job. But Joe, what I was amazed about, there wasn't a tremendous amount of pushback from the bench on either one of them. What do you think of that? What do you take of that?
I think it's quite clear where, again, maybe it's bias, like we all have, if you've done more, routine litigation in the past, eyewitnesses despite all the courtroom TV shows and dramas that are out there, eyewitnesses are rarely reliable, so there's this inherent bias. You want to see the world through rose-colored glasses, but recognizing that internal bias, just trying to stay as rational about it as possible. I think the reality is that our arguments are grounded in current American jurisprudence, whereas the state's argument wants to take us through this sort of circular journey that takes us far away from where the law is right now. And I think that was evident. This really was a showdown between some heavy hitters. I mean, Aaron Murphy from Clement Murphy, some of the top litigators in the country as it relates to constitutional issues.
Yep.
Pete Patterson, who's a close friend. Cooper and Kirk is one of the top law firms in the nation on this issue.
They're one of the big dogs on the block when it comes to that stuff.
And in full disclosure, I mean, Jeremy Feigenbaum, he is himself, he was representing the New Jersey Solicitor General. He is a big name out there, and he has argued cases before the U.S. Supreme Court.
I thought that he did. I could tell, even though I didn't agree with many of his arguments from a philosophical and legal standpoint, I thought he is definitely a well-seasoned orator.
Yeah,
he argues incredibly well.
He is known for that. He was on, if I recall, he was arguing before the Supreme Court on Trump v. Casa.
Oh,
so
okay.
Not just Supreme Court, sort of experience on major issues. So, this really was a collection of heavy hitters.
It was. And for those of you, and we'll link it up below so you guys can listen to it yourself. It is a very well presented oral argument from both sides. I want to actually get through some of the things. Let's start with Miss Murphy, because she was the leadoff hitter. She went first. I believe she was about 5 minutes into her presentation before the first question even came from the bench, which I found odd, but pleasantly odd. And then I noticed that many of the questions she was getting was not at all about her legal theories of common use and dangerous and unusual and things like that. But you seem to have a couple of justices that wanted to nitpick about the record. Did the record actually establish that these are in common use? What
Yeah.
did you take of that?
Yeah. And, I'll turn maybe just briefly to the state's arguments here, because I think in both, and this is, sort of, inside baseball on this whole thing as well. I mean, as you and I both know, and viewers should know, uh, overwhelmingly these cases are decided on, quote unquote, on the papers,
Right.
right? The oral argument component is not as significant in
For
the
show.
end product,
Yeah.
And so, what are we trying to really do? We're trying to dress up the key points in the arguments that have been made. And there's an extensive record on these cases. I mean,
Yeah.
some of these are pre-Bruin cases that have been up and GBR'd and back down again and come forward in multiple iterations. So there's a long thousands of pages of case record on this and development. So but some of the states are. I think the state's position on all of this sort of distills down to maybe 5 points, and I would say maybe 3 of them are legal. One of them is maybe procedural, and then there was this theme of like a scare tactic
The
interview.
machine gun theme?
Yeah, the machine gun question, right? The idea that, oh, well, ipso facto, if you decide that AR-15s and the like are protected arms under the Second Amendment, you're in essence declaring that machine guns are also protected arms.
Well, and the government, excuse me, the plaintiffs got pressed on that a couple of times.
Yeah.
And they didn't give in. And then at one point, the court even pushed back and asked, well, like, what would this do for bump stocks? And that was on Miss Murphy's rebuttal. And I thought she actually missed an opportunity to shut that down real quick, which is, if we start with bump stocks and we just go, well, does the Second Amendment cover that activity?
I mean, look,
I don't know if it does on bump stocks. You know what I mean? So
yeah, look, I mean, I think our case records are pretty clear. At no point were we challenging that. Like, that's just not been part of the calculus or the analysis or anything that we're
it's not part of a winning strategy either, is it?
That would be the problem.
Yeah,
do I personally think these are protected arms? I think there's a question there that we should.
There's a plausible legal argument for it. There is no doubt about it.
I don't think we should be afraid of that argument at some point, but it's just not. It's not germane to this case, and it's not the time for it. So, and I think our side was pretty quick to sort of bat that down. Right.
Couple of points. First of all, when Bruin came out in the summer of 22, Justice Thomas wrote that we've been using this 2-step test and it was one step too many. Okay. It was supposed to be a 1-step test, but Bruin has developed into a 2-part test also. Now, the first part of the test is, does the text of the Second Amendment cover this activity? That question was pressed upon Miss Murphy. And I wrote this down because I thought this was a damn good answer. The first part of it isn't really so much an element as much as it's just a gut check. Right? Is the Second Amendment implicated here at all? I thought that was a very, very good way of putting it, because she said that, once that gut check is met, then we go to history right away. And so I thought she did a really good job of that. The other thing, and this is something I noticed that at least one justice, maybe 2 justices glommed onto this, was this argument advanced by the state that the terror of the people is sufficient enough to actually warrant banning platforms of firearms. Terror of the people. And what did you make of that? Was that just part of the scare tactics that you think the state of New Jersey was trying to permeate throughout their argument?
No. I think really, I mean, this starts getting pretty geeky, right?
Yeah, let's do it.
But there's sort of two main themes that the state is arguing here. One is, as you say, what is the procedure under Bruin, right? And what is the ordering of the steps under Bruin? And the state's position here is that the common use test, as we extracted from Heller, is part of the step 1 analysis.
Right.
In other words,
it is not.
We're asking the question that, so the 2 steps are, we have the textual question: is the plain text of the Second Amendment implicated? If so, then the burden shifts to the state to demonstrate that there's a historical tradition of firearms regulation that ties to that modern law. And so what the state is saying is this whole common use thing is part of step one. In other words, we do the common use test to determine whether or not it's an arm as defined in the Second Amendment. And then if so, then we move to the historical analysis.
Right.
Right. So this is where the states tries to steer this way off the rails, and that's why I think Aaron Murphy, some of the points you raised were certainly salient and meaningful in the oral arguments. But I think her opening statement within 30 seconds of getting the mic and starting her opening statement there, I think she made it pretty clear to say to the court, hey, all that history stuff, we don't have to do it here. That's already been done.
That's right.
The common use test is step 2 under Heller.
That's right. When we're talking about, because and this is the way I try to explain to people is that gun laws do one of 3 things, and they all ban something, right? They either ban people, places, or things. Right? That's what they do. Exactly. When it comes to the things, we don't have to do a historical analysis for that one. It's been done. It's totally been done. Places, people, like we saw with Rahimi and things like that, yeah, there is room for some types of historical analysis. But when it comes to things, we've done that one already. And I thought that Ms. Murphy did a really good job of that. Let me ask you about Pete Patterson, who was actually arguing on behalf of your plaintiffs, who I thought, again, did a fantastic job. He got pressed, and this was a very interesting conversation. The numbers. What numbers actually constitute common use? And he was getting it from, I think, some judges that were on board with him, and then he was getting from judges that weren't on board. What did you make of that whole discussion? Because I thought Pete did a pretty nice job of withstanding that.
Yeah. And, this is where that sort of, and this is thematic in terms of policy debates too. This idea that we want to try to conflate, assault weapons with machine guns, and where's the lower bound? I don't think there's a point to arguing about common use when it comes to things like the AR-15. We don't have to find a line.
It's like arguing about whether or not the sun sets in the west, right? It's kind of obvious.
Yeah, we don't have to find the fine line in the sand where it's like below this threshold is a question, above this threshold there is no question. The numbers as it relates to, and this kind of relates to the state's counter arguments about sort of the procedural record and whether or not, that this circuit court should consider this de novo and make a merits decision, or whether or not this case should be remanded for further proceedings. Which would be catastrophic, right? That would be catastrophic for us. I do think that there's a strong argument that this is the best contender for cert for the Supreme Court, and we want this case decided on the merits now.
Absolutely, you do.
Yeah, and I think we made those points, but I think Pete Patterson did a pretty good job of, sort of summarizing what the state of things is there.
Well, I think he did a good job of saying, hey, listen, maybe there is some kind of a threshold if we're talking in the hundreds of thousands, but that's not germane to today's discussion, because what we're talking about here is something that's in the multiple millions. And so I think he made it very clear that when we're getting into that type of numerical value, there really is no question about it. The other interesting thing, one of the justices pressed them on, okay, so maybe magazines up to 30 rounds are constitutionally protected. What about going beyond? What about the 100 round drums and things like that? What did you make of that question? Was that just some judge who wanted to have his voice heard? Or do you think that there is actually a possibility that we could get a ruling that says the Constitution protects magazines up to 30 rounds, but not beyond that?
Well, and again, I think it was oddly put in Pete's camp, because the magazine question is not technically part of Cheeseman v. Platkin. That's part of NRA and ANJRPC's case. So he wasn't technically the right attorney to ask that question to in terms of who was in the room. But I think he nailed it nonetheless. The question before us is not what the upper bound is. That's for a legislature, right? Our question is 10 plus 1. Is an 11 round, is anything below an 11 round magazine constitutionally protected, and anything above 10 rounds not constitutionally protected?
Have you ever read Barry Arrington, who writes a lot of briefs for NAGR? Have you ever read his magic bullet theory?
Yeah, exactly. But
it is. You sit there and you go, that's ridiculous. And you're like, you're right. That is ridiculous. That's why we're arguing about it.
That 11th round somehow makes it somehow different.
Outside the protection of the Second Amendment at that point by adding that one extra round. Okay, let's talk about how does Jeremy pronounce his last name, the Attorney General for New Jersey?
Feigenbaum.
First of all, like I said, a very, very skilled orator. Good. Now, of course, he starts his argument with the same way, and this is where this is going to go. He starts with the horror stories, right? We're going to talk about the slaughter and the massacres and things like that. He immediately then shifts to the common use test, and that it goes well beyond just a numerical value. And then one of the things that and then he also ended up really trying to muddy down the dangerous and unusual to try to get the court to be convinced that it was dangerous or unusual or unusually dangerous or any other watered down term, and actually spent about 4 minutes of his oral arguments going through an English and grammar lesson for all of us too. But I felt that he got more pushback from the bench than either of the two plaintiffs' attorneys. What's your thought on that, having sat in the courtroom?
I mean, again, it's just a general observation here that the state really trying to lose. Am I good? The state is really trying to spin out what the definitions of Bruin and Heller. So, and I think the justices saw that with a great deal of skepticism. Visibly his mannerisms in the courtroom, he looked agitated and excited, a lot of hand moving, and he looked very animated.
Is that his normal style, or did you feel that he was? Is that his normal style? Is he normally that animated, or?
Hard to say, but I mean, I think he's in a difficult position. I think he did an admirable job trying to argue a very difficult position where, it really is a bit of bait and switch on what the general principles of Heller and Bruin are. And, he was really taking things off the rail there. And I think the judges that were sitting on the bench yesterday, there was some obvious skepticism vis-a-vis the state's argument. I forget whether it was Hardiman and Porter that pointed it out, that if you were to apply things the way you're advocating here, the Second Amendment is no right at all.
Well, well, that's a good segue, because at one point he was pressed on, is it really in common use, just in common use, or is it in common use for self-defense? And of course he said it's in common use for self-defense, which, if that's the position of New Jersey, I feel very, very sorry for all the New Jersey sportsmen and hunters.
Yeah. Well, and beyond
because that would mean that hunting rifles and things such as that, shotguns for bird hunting and things like that, in the eyes of New Jersey, are not even constitutionally protected.
And there were those on the bench yesterday that pointed it out too, that, really, I mean, this gets philosophical, right? But if we go back to, the sort of English Bill of Rights understanding of what the right to keep and bear arms is, going back to Blackstone in the 16th century. I mean, he described that as the sort of auxiliary right that protects the right of the people to resist tyranny. And that's been an understanding of the right to keep and bear arms going back to the glorious revolution in the English Civil War. So
if history is the guiding light, when did we write the Second Amendment? No one was worried about going out and hunting when we wrote the Second Amendment, right?
Yeah, the prefatory clause doesn't say, the security of, individual civilians in their.
Yeah, in order to eat a balanced diet, we all need guns to hunt, right?
Yeah, exactly. It's clear what the overarching theme is. Now, of course, Heller was, primarily dealing with bans on common handguns. And, again, I don't think there's any dispute in reading Heller that they described self-defense as among the core.
Among them, right.
Among them. And that was central to the question of whether or not handguns are protected under the Second Amendment. But I think it's clear, not just in dicta, but in the core holding of Heller, that is just among one of many understandings of what uses are contemplated under this common use test. It's use for lawful purposes, which includes things like self-defense and, as you say, hunting and sporting purposes, but also, to maintain and preserve a balance of power between the people and the government.
And that's what I want the viewer to understand about the common use test. Is the common use test is so critical for many reasons, but in essence, the common use test allows the American people to dictate the confines of our Second Amendment rights, not politicians, not judges, not those that don't know anything about firearms whatsoever. The American people get to decide what's appropriate for self-defense, what's appropriate for home defense, what's appropriate for hunting, all of those things. We get to decide. And that's the important thing about that common use test. Let
And
me ask you. Yeah,
I'll add
go ahead.
this though. If we were to rewind the clock and go back to the sort of oral arguments at the 3-judge panel back in July,
Mhm.
I think there was a lot more back and forth between our side and their side and the judges on that panel on this question about self-defense and the appropriateness of assault weapons and large capacity magazines, in the context of self-defense. And I won't say that we did a less than admirable job at the original 3-judge oral arguments,
But
but
you were more
but
pleased with what happened yesterday?
I
Is
think
that
we
a fair
learned
way
a
of putting it?
lesson. Yeah, I think we learned
Good.
a lesson, and I think we refined those arguments yesterday, and I think that shined yesterday at our oral arguments before the full circuit for sure.
A couple more questions, and then we'll get to the punchline here.
Sure.
There was a justice who asked of the Attorney General yesterday, why are we using the 21st century meaning of unusual? Why don't we use the 18th century version of it? And he, of course, pulled out what the definition was, which isn't that radically different to how we would define it today. But then his question to the Attorney General is if we use that definition, don't you lose? What you make of that?
Yeah, I don't know, and trying not to see the world through these rose-colored glasses, but
Well, we're in the Second Amendment community. That's the last thing we should be doing, you know?
yeah. I mean, I think when you really look at their line of questioning there, it's clear where these judges are where their heads are at on this because I will reiterate here. Our arguments were entirely consistent with the law,
Yep.
and the original. We have Heller, and then Bruin doesn't really change the calculus here. Bruin just simply says we meant what we said in Heller, and so if we go
That's right.
back to Heller and the way the Supreme Court, sort of originally sort of used these terms and the binding jurisprudence that applies to the Third Circuit and all courts across the United States, I mean that they do lose for that exact reason. Unusual, and then the state tried to twist this into, well, it's not an or proposition, it's dangerously unusual or unusually
Yeah, but they would
dangerous.
take dangerous or unusual because, even most people on our sides will admit that, well, firearms, weapons in general are dangerous, especially
Yeah,
in the hands of idiots.
yeah,
So it really does come down to the unusual test.
yeah, it really does. I mean, again, as it relates to those elements of their argument, I really don't see how a circuit, given its current composition and the likelihood that they're going to try to faithfully apply current Supreme Court binding precedent, I just don't see them buying the state's arguments on this. I do see there were little hints at some, I would argue, or some areas where there are perhaps some areas of legitimate concern with how courts might interpret certain things, but I don't think it's relevant in this case.
No.
And the reason I say that is because we saw this both thematically yesterday, but also in the recent decision in Coons and Siegel, which is our two carry cases, where there is this sort of broader, and I think even courts that are trying to do a good job with this might struggle with this notion of like the level of generality when we look at historical, analogs. The state tries to draw very broad principles out of what they decide are traditions of firearms regulation, right? And we saw that with their sort of diatribes about Bowie knives and
And the funny thing is, if you take a look at most old Bowie knife laws, what they do is they regulate the carrying of Bowie knives, not the actual possession of them.
and that's the question. And unfortunately, I think to some degree, the Rahimi court kind of opened the door a little bit to this because they
The
kind of
Rahimi court opened a lot of doors that shouldn't have been open, but
yeah.
that's a whole nother video we can do sometime.
Exactly. But at the end of the day, I think the argument stands that we don't have to worry about that because this isn't actually a historical analysis. The burden, and this ties to this question about, the case record. And I think we nailed it there when we said, essentially the burden was on the state to make these arguments about what is or isn't protected. They failed to do so. It was the burden had permanently shifted to the state to demonstrate that the common use test is applied to all these different arms. Forget about the AR-15, all the different things that are denoted in our law. That responsibility remained with the state. They didn't raise those issues, and so we shouldn't have to relitigate any of that stuff. I think if the court buys the argument that the history piece is done and we don't have to think about those things, 90% of what the state's talking about is frankly irrelevant, and they just
totally irrelevant. Yes. All right. You ready for the tough question now? Here we go.
Away.
I'm gonna make Joe LoPorto get in front of his crystal ball. And I won't hold you to this. I will not hold you to this, because if I had $1 for every time I was wrong about a prediction, I would be retired already. Okay.
Yeah.
But if you were a betting man, where's your money going? Where do you think this thing's going to come down?
Well, so I made this prediction a few weeks ago at just sort of in the hallways at Gun Rights Policy Conference back in Salt Lake City.
Down in Salt Lake.
Yeah. So my prediction then was that I think we have a 70% chance of being the circuit court split on the question of assault weapons. And the reason is that this is before we knew for sure that Judge Mascott was going to be on this court, because right now we would look like 8-6. In this case, best case scenario might be 9-6, because we have a 15-judge panel here instead of the normal 14. So that would have been the best case scenario. But before Mascott got there, there was this possibility that we might have ended 7-7. Now, if you recall, just based on the procedural posture here, we technically won at the district court level, right? The lower court decided that the Colt AR-15 is protected under the Second Amendment. While that was a very ambiguous decision, and there was much to talk about there in terms of what that actually meant, we were nonetheless, our position going into court yesterday was the lower court decided Colt AR-15s are protected. So in the event of a tie, we would have that original holding would have stood, and we would still be the split, vis-a-vis the Fourth Circuit and the Seventh Circuit and the Ninth Circuit, all the courts that have gone way off the rails on this question.
Yes.
So if that's the like lower expectation, was that lower court win stays, I mean, we're going to be somewhere between 7 or 8 judges, 8 to 9 judges in our favor on this issue.
Oh boy.
I think we win. And I think this court, maybe just given the expedience with which Judge Mascott was brought into the court, and the fact that, I mean, what a heck of a way to start your career as a
judge. Here's a light little case for you on your to break yourself in here.
I mean, I think there's fire under the Third Circuit to get this thing wrapped up, in a timely fashion, so that perhaps we have a final decision by, let's say, January, which means we could be up on certain, a petition.
Well, because if the ban is struck down, Matthew Platkin will appeal before the ink is even dry on the order, and away we go.
Personally, I think we're looking at, worst case scenario 8-7 on this, but I think it's probably going to be 9-6.
And for those of you around the country tuning in and like, okay, well, great. What good does that do me? I don't live in the Third Circuit. I'm nowhere close to New Jersey. Understand that one of the big reasons that the United States Supreme Court avoids this issue, and let's call it what it is, because they have avoided this issue, is they always fall back on this whole, well, there's no circuit split. And then that gets into the jurisdictional bubbles and all those things we won't geek out on here. But all of a sudden, if you got the Third Circuit going, no, these bans are unconstitutional, well, away we go. I mean, now the Supreme Court has to step in. They have to step in. And really, if this case was developed on a trial record, which is what I'm hearing here, this really kind of moves into pole position, doesn't it, as a well-percolated, well-developed case ready to be resolved by the Supreme Court.
Yeah, I mean, again, I'll confess my bias.
I know. When I talk to Costas over at SAF, he's like, the magazine case has to be Duncan. Why? Well, because that's his case. But I get it. It's all good.
But again, the court, not only are they looking for adequate percolation and whatever that means.
Right.
And they like to see circuit court splits before they take the issue, and they want to see all these like final merits decisions. They don't like our interlocutory case, all the things the Supreme Court has told us, in recent terms. The other factor here is that, we're the only court where the state's coming off a loss. And I think that historically, the court in most other areas of the law has been more willing to take up challenges where the government is losing and the government is seeking certiorari. So you put all that together, I think we're the case. I mean, and the fact that we had all those heavy hitters in the room yesterday, the fact that we had all this firepower, including from the state, who brought in some big guns.
Yeah, it was a Donnybrook, man. It was a battle royale yesterday. Yeah.
It was a battle royale, and I think that there's a lot of folks in the room that were thinking like maybe this is the one, and we're going to be redoing this before. Well,
and I think you're beginning to see that in our community too, because there was a heightened level of interest in this case, and I think that there was the rumors getting out there that, hey, there's this shift going on over there in the Third Circuit. And then, of course, you had some stuff at the grassroots level in New Jersey that kind of brought some attention, because you guys you're kind of the ground zero of the Second Amendment revolution right now out there. So
I think what's the expression about iron being forged in fire? We've got a passionate base of supporters out here that are just tired of getting
beat down,
just sort of kicked in the wrong places. And we've got we got some great tailwinds here. I think this is the case. I think we've got a bankable 8 votes in our favor, and we'll see what happens in a few months. Yeah, exactly.
All right. Final thing, Joe LoPorto. Let's talk about the New Jersey Firearm Owners Syndicate. Everybody out in New Jersey, and even if you're not in New Jersey, like I said, man, New Jersey is becoming ground zero. You can go back and look at my library. You can see some of the geeky videos I did about what's going on out there. Get in the game with New Jersey Firearm Owners Syndicate. Joe, tell the folks how they can help you all out and get
Yes, certainly. I know we're a state organization. We are independent, and so what I will say there is that we work hard to preserve working coalitions with all our national partners. We're not tied to one or the other. We were working with NRA. We were working with SAF. We were working with FPC. With anyone who is interested in doing work here in the state of New Jersey, support our work. You can find us at www.njfos.org. You can follow us on X at NJFO Syndicate. And keep tabs on what's happening here in New Jersey, because I have a sneaking suspicion that there's a lot more to come.
I have a sneaking suspicion that I'm going to end up doing in 2026 a whole bunch of videos about it. It might be my new Illinois.
That's right. I mean,
yeah, you know how like Cheap Trick is like really big in Japan. Washington gun law is like really big in Illinois. So
yeah, that's it. Well, look, I appreciate the fact that you amongst the many that are out there are with us, sort of fighting behind enemy lines, and I think we need to see unison coast to coast.
Hey, listen. Anytime you guys need me out in Jersey, I'll gladly come out and help you out.
I'd love to host you here.
I would love to have you. All right. Listen, Joe, thanks so much. We slapped this thing together yesterday, so we're doing this on the fly. You have been awesome. I'll get to see, if I don't get out to Jersey before then, I'll get to see you in Vegas in January, I'm hoping.
Yeah, that's a good possibility there. I'd love to connect with you out there.
Let's do it for sure. All right, everyone. He is Joe LoPorto. He's with the New Jersey Firearm Owners Syndicate. We're going to link up once this thing gets back on replay. We will link up the oral arguments down below, so you don't have to take Joe and I's word for it. You can geek out on it for yourself. Joe, thank you very much for being here. For all of you who tuned in live, thank you very much. For all of you who are watching on replay, thank you very much. And remember, we got 2 live sessions coming up soon. We got next week, we got on October 22nd, we're going to do Faith Under Fire. We're going to have a nationally renowned expert on House of Worship security. Big issue going on nationwide. Doesn't matter what religious affiliation you got. There are security issues, and I really need the churches to start getting a little bit more serious about that. And then remember, back on November 10th, we'll be back for our second Behind Enemy Lines with Costas Morrow. Joe, thanks a million, brother. You're the best.
Thank you, brother. Talk to you soon.
All right. Talk soon.